Good evening and welcome to the latest in a series of webinars from the Medical Defence Union. My name is Ed Farnan and I'm one of the medical legal advisors here at the MDU. I'm joined this evening by two of my colleagues in the advisory department, Dr Nandasoma and Dr Sarah Jarvis. And tonight's topic is on handling challenging patient interactions effectively. The first part of the presentation will be by Dr Jarvis, who will be talking about written communication with patients whose behaviour is unacceptable, and then I'll give a short presentation on dealing with criticism on social media. While we're doing that, Ed will be in the background dealing with or fielding some of your questions, and just to try and make that as efficient as possible, we'd encourage you to get your questions in as early as possible and try and keep them as short and to the point as possible. That's because we're expecting, something of the order of several hundred people to attend this evening. And while we can't hope to get through all of the individual questions, the earlier you get them in, the easier it will be for Ed to identify the themes that are coming up, and then we'll have a discussion about those questions after the two presentations. If you join late or if you have to leave early, the presentation will be on our website in due course, and you'll also be given a certificate of attendance, which should come out to you probably towards the end of this week. So without further ado, if I can pass over to Sarah to take over with her presentation, which will take about 15 minutes. Then I'll speak for 15 minutes or so, and then we'll have your questions. Sarah, over to you.
Thank you very much, Ed. Good evening, everybody. Thank you for joining us. As Ed has said, we're going to touch, first of all, on this sort of written communication where there's been challenging behaviour by a patient. And certainly at the MDU, we're mindful that this can cause quite a lot of distress to clinicians, to the staff around them, and so on. Very interesting, when you were asked, when you were signing up for this seminar, how many of you felt confident to draft a warning letter? Actually, less than a quarter of you said that you had any confidence at all in drafting a warning letter. And the second question was asking about the level of confidence in drafting an acceptable behaviour agreement. And for that, just under a fifth of you had any level of confidence in drafting an acceptable behaviour agreement. Hopefully by the end of the presentation, those numbers will definitely have improved there then. Okay. So I want to chat first of all about generalities of warning letters and acceptable behaviour agreements, how they can help you to manage patients' behaviour, but also how they can protect you from criticism in the future. It's important that you follow certain steps and so on, and that you're able to justify any decisions that are made with regard to patient behaviour. And we'll also look at what they should look like. And if we perhaps take an example where you're working in a general practice, either as a practice manager or reception leader or GP, and you can hear a huge amount of shouting at reception because a patient has turned up to collect a sick note that the doctor said was ready, and that sick note is not ready when the patient turns up at reception. So sometimes we know that speaking to a patient, if they're using inappropriate tones when they're speaking to us and so on, is enough, but actually sometimes we need to make things more formal and to consider written documents and so on. And when we're talking about patients and their acceptable and their behaviour and the expectations, it's really important that we all have policies which are kept up to date, that dealing with conflict and unhappy patients is part of the inductions for all staff. And of course, that's really important for staff who may be with us only for a short amount of time, for example, locums or temporary staff. And it's really important that the sort of policies of zero tolerance and what to do if a patient is behaving inappropriately are easily accessible. And it's quite important that people know who to contact. And in general, it would be their line manager, but generally the sort of partners who manage the practice will ultimately have to make the decisions about what to do. And it's very interesting when we consider what unacceptable behaviour would be. And sometimes it might be offensive language, it might be verbal abuse, swearing, abusive comments of a sexual nature. We'd include in that racist, sexist, homophobic or other discriminatory remarks. Offensive gestures can cause a lot of distress. And of course, at the sort of more extreme end, then luckily still very rare, but you can get threats, perhaps verbal or physical, and staff can feel bullied or intimidated. Very rarely we do hear of attempted assaults where contact's not made. So, for example, if a patient attempts to spit at a member of staff, and very rarely then brandishing weapons or objects with a sort of threat of inflicting any harm. And we should include in this as well stalking and other forms of harassment. So it's important that we recognise that unacceptable behaviour can, I suppose, span quite a wide range of concerns. And I think we always recognise at the MDU how very stressful these situations can be. I think everybody in the room will recognise that the pressures on the front line at the moment are incredible, and then having to deal with rude, abusive behaviour on top of that, I think can make the most resilient of people feel quite distressed and frightened as well. What I would say is that it's important to remember our own feelings as part of this. We would always say to bear in mind HALT or HALT, and that trying to deal with stressful situations when you're hungry, angry, late or tired can add to the stress. It's really important that you share things with your colleagues, get their support and their input. You just need to go and get a cup of tea for 5 minutes if a patient has been rude, so that you're able to collect your thoughts and then to move on. And there are certainly lots of resources for support which are available on the MDU website. We have a section on that. By having clear policies and so on, that should hope to minimise the stress, that people know who they can go to and what to do. And of course, we'd encourage you to remember that the local medical committee, the LMCs, and the defence organisations can often be helpful when you're having to deal with these challenging situations. In terms of warning letters, it's really important that they're clear. We do sometimes review warning letters to patients here at the MDU, and quite often it's not easy to tell that this is actually a warning letter. So I think it's really important that they are clear. It's important to deal with behaviour in a timely fashion as well. So sometimes sending a warning letter several months after you've decided that behaviour is unacceptable is unlikely to carry much weight. And it's important that you feel comfortable with the decision that's made and that you document the decision making around them. So you've collated the evidence, you've got discussions of what's happened and so on there then, and that's important. So if we look at warning letters, it should always include the name and the role of the person who's sending the letter. And ideally that shouldn't be someone who was involved in the incident. So if GP Dr. A, the patient was rude and abusive to that doctor, it's often better for Dr. B to be involved in the drafting of that letter. And I think making very clear the description of the incident is very important, so that you actually say what the behaviour was, so that there is no room for misunderstanding or for a patient to minimise what went on. And actually the impact of that behaviour on the staff, perhaps on other patients in the waiting room, that needs to be set out very clearly as well. It's important to say how you're going to document the decision that's been made. For example, whether you're going to put an entry on the clinical record about the events that have been causing concern, letting them know if you're going to tell anybody else who'll be informed of the behaviour or copied on the letter. And generally, you would have to give a date when the warning would be removed or any marking of the records would be removed. It's helpful to set about how the decision can be challenged or how a complaint could be made if the patient is unhappy. And I think a sort of top tip is to set out at the top in big bold letters that it's a warning letter, so that there is no doubt there. And when you set out the possible consequences of a repeat of the behaviour, there are all sorts of things that you might be considering. For example, restricting the patient from entering the premises, or they may go to one of the safe haven schemes, for example. But of course, there may be times when actually you need to notify the police. And there may be times where you then feel that the doctor-patient relationship has broken down if there's a repeat of the behaviour, such that you're going to remove the patient from the list. So really, what you would hope that the warning letter was set out for the patient would be clear information for them to reflect upon, an opportunity to amend the behaviour that's caused concern, and hopefully the chance to rebuild the doctor-patient relationship. It's really important as well to bear in mind that, of course, you have contractual obligations when you're a contract holder about the registrations and deregistrations, but doctors also have professional obligations in terms of their regulatory body, the GMC. So from the practice perspective, it's helpful that a warning letter can show that you've taken some steps to try and get a relationship back on track, and hopefully that is the end of the matter, and the patient then will cooperate with the practice, and that behaviour will not happen again. But if it does happen again, you've laid the groundwork for the possible removal of the patient from the list, because there is a clear expectation. The GMC has guidance on ending your professional relationships with patients, and what it says in there is that generally the patient should have been given a warning unless there has been violent or abusive behaviour such that the police have been called, and that warning should have been issued in the 12 months before any removal. So by going through the process of issuing a proper warning letter, if matters escalate, then you've set your stall out and you've got documented evidence of what you've tried to do. If we turn then to acceptable behaviour agreements, they're really another way of trying to get things back on track. And the types of situations where these can be helpful may be when you're prescribing medication and the patient is requesting for that repeat medication to be prescribed early, or they're losing medication, that sort of thing. It can be helpful to deal with that. And also if a patient is, I suppose, making unreasonable demands on the practice in terms of requests for appointments and interactions and so on. And of course, none of these warning letters or acceptable behaviour agreements would stop you. You still have to give the clinical care that the patient needs, but it's important that consideration is given to the best way of doing this. And actually, sometimes it's felt that involving the patients in these acceptable behaviour agreements might actually make the patient have more ownership and be more involved in the process, which is important. And again, what they can do is that they can show, set out what the patient is doing that's unacceptable. Again, setting out the impact that that behaviour has on other people and how it sometimes stops the effective delivery of healthcare. And again, making clear whether if their behaviour does not change, what might happen. So, for example, if consideration might be given to transferring them to another service, and so on there then. It's really interesting when we discuss these, whether you feel that positive or negative wording might be helpful. And I suppose that when you're trying to get a patient to engage so that their behaviour improves, just as an example, whether it's better to say something like, you will not swear at staff, so a do not do something, or whether it's to say, you will treat members of staff with respect. So the positive expectations there. And I think it's always helpful to set out what the healthcare provider will do. So whether, you know, the surgery, for example, would give consideration to trying to book a regular appointment with a GP of their choice every 6 or 8 weeks, that sort of thing. So I think that's important there to bear that in mind. And always when you're considering warning letters and acceptable behaviour agreements, it's important to consider whether there are any other factors that are perhaps driving this behaviour or that are linked with it. So, for example, if there are conditions that need to be treated that might be dealing with how somebody is behaving, if they're in a very stressed situation, for example, if they're behaving as a carer, whether that support and so on needs to be put there as well. Need to make sure that the patient actually can understand what they're agreeing to if you're asking them to sign up to an acceptable behaviour agreement, and make sure that that behaviour agreement doesn't do anything to stop clinical care that you have to give to that patient. And always the GMC guidance is in the background here, being honest and trustworthy in signing documents and taking reasonable steps to ensure that what you're signing is correct. So not making, I suppose, promises that are not deliverable in an acceptable behaviour agreement, but making sure that you follow through there with that. And hopefully then the patient will engage with the process and matters will improve, but if they don't, you can show the steps that you've taken before considering removal from the list. Again, make sure the correspondence is very clear. So to say at the top, it's an acceptable behaviour agreement. What's going to happen if the behaviour continues, and so on. I think it's really important to make sure that staff are well supported, and sometimes after sort of incidents that have caused a lot of stress and upset for staff, that you might need to have a debrief for that member of staff to sit down and to go through with them to make sure that they're quite safe and so on, and that they feel back and able to get back to their duties and so on. Again, it's really important that you document the situation well so that you can justify the action that's taken and remember your GMC and your contractual obligations. We do sometimes see cases where, for example, a patient has made a complaint as a result of a difficult interaction with a member of staff. And what you can't do is to conflate a warning with a response to a complaint. So if a patient has behaved in an unacceptable way, you need to deal with that at that time rather than wait to receive a complaint letter and then try to deal with things at the same time. So we would always say that any complaint correspondence should be dealt with separately from any warnings and acceptable behaviour agreements. And that's really important because the Ombudsman can be quite quick to investigate situations where a patient feels that they have been unfairly removed from the list. And the GMC guidance is very clear that you should not remove a patient from the list simply because they've made a complaint or a claim. So it's important to separate those processes to deal with that. And we've already said actually dealing with things in a timely and consistent way is really important, both for the patient so that they can modify their behaviour straight away, but also so that you can demonstrate to your staff that you take their well-being and their safety seriously as well. That's quite important. So I hope that's been a very helpful run through warning letters and acceptable behaviour agreements. And we're now going to move on to Ed's part of the presentation.
Many thanks, Sarah. Thank you for that. I just reinforce before we move on to my presentation the request that you get your questions in nice and early. You can submit questions using the chat box facility. If you get them in early, get them in preferably as short and as to the point as possible. We'll try and get through as many of those as we can after this part of the presentation. And before I start, I'm just going to ask you, just as you did when you registered for the webinar, you answered some questions which were relevant to Sarah's presentation. If you can maybe contribute to a couple of polls just to see the impact that social media may have had on you as doctors. And the first poll question really is, have you ever been criticised online by a patient? So if you want to put your responses to that at this stage, either yes or no, and then we've got a couple of supplementary questions. And while we're waiting for you to respond to those questions, just to say that if you've joined late or if you have to leave early, this webinar will be recorded and will be available for viewing on our website, along with all our previous webinars on other matters such as remote consulting and prescribing, GMC's consent guidance, and others which have been done in the past. So we can conclude that question. So yes, a significant number of doctors have been criticised online by a patient. Still a majority, fortunately, of this group, but 27% is a fairly hefty percentage have been subject to online criticism by patients. So on the basis that some of you have been criticised, for those who said yes, can I ask, and again, how did you respond to that? So did you ignore it or take no action? Did you report it to the website but found that it was not removed? Conversely, did you report it to the website and find that it was removed? Did you take the opportunity of adding a comment to the online review? Or did you deal with it directly with the patient as a formal complaint? So again, just give you a few moments to answer that. And let's see how we've got on there. So nearly half of the folk who have been criticised ignored it or took no action. Interestingly, of those who did report it to a website found that it in fact was removed. A very small number added a comment to the review, and a significant number dealt with it directly as a complaint. More importantly, from your perspective, what impact did that therefore have on you? What were the effects of the criticism? Did it affect you by feeling that you no longer trust patients or that you treat them differently? Did it change the way you practice? Did it increase your anxieties about either being sued or receiving a complaint? As a result of the online criticism, did it mean that you left the practice or retired, or did you have health problems? All of these, I think, are possible, and some of you, I imagine, will identify with more than one of these. And again, just give a moment for those answers to come in. And let's see how we got on. And again, I think what that shows is that while only a small number were moved to actually leave the practice or retire, it's had a significant impact in some way on all of you. So if we can move on, and I should confess that due to some IT difficulties, I am going to unleash my inner Chris Whitty and ask Sarah to move my slides on for me. So if we move on to the next slide. And this is just really to illustrate that the genie is out of the bottle in respect of social media. It is there, it's not going to go away. And these figures show that tens of millions of people in the UK are users of social media to some extent. And this is just an example of 3 types of social media. There are many others are available. And I would also highlight that concern about online criticism is not an issue unique to the UK, and nor is it new. We've seen research from 2017 in the United States, which showed that over 3/4 of doctors who were asked were stressed by online criticism or the possibility of it. It was a study from Harvard, which looked at over 800 doctors and nearly 500 patients from 4 hospitals across Massachusetts. And that study found that 78% of doctors thought the possibility of negative online comments added to the stress of their job, and 46% said that online rating websites had the potential for harming the doctor-patient relationship. So that shows that it's not new, and it's significant. And if anything, I would imagine that the chances of those problems occurring have gone up as social media websites become more used by people. Next slide, if we can see that one, shows that while I'm not here exclusively to bury social media, there are things which we can praise about it. It has the potential to engage people who might otherwise not have been engaged. It does help in establishing networks of colleagues. It does facilitate access to information about health services, and that can be potentially a benefit, for example, with people who have rare or unusual illnesses or who are socially isolated. So it is something which has its own benefits. But on the next slide, I show that there are potential problems. I highlight the first one there, which is the blurring of boundaries between the personal and the professional. And that would be, for example, with patients making direct contact with their doctors on social media, and also information from doctors being immediately accessible to their patients, to their colleagues, and even to their regulators in a way which may not be helpful for the doctors. In terms of negative feedback, I think we find that dissatisfied patients are increasingly ready to use social media and online rating sites to post comments or complaints. And while some online comments are undoubtedly positive and welcome, some can certainly feel unjustified or misleading, and occasionally it strays into the area of being abusive, offensive, or even potentially defamatory. And in some cases, an unfavourable mention of a doctor by a patient could still be included in an online search result, even if the original post was from many years before, and we'll touch on that later. If I move on to the GMC's guidance, this is their confidentiality guidance about responding to criticism in the media, which includes social media. And the GMC does recognise that criticism about doctors can include inaccurate or misleading details about a doctor's diagnosis or treatment or behaviour. And while this is undoubtedly frustrating, it doesn't relieve you of your duty of confidentiality. And it's important to bear in mind that disclosures of patient information without their consent can undermine your patient's trust in you and also the public's trust in the profession. And a public dispute between a patient and a doctor, even if it doesn't involve the disclosure of confidential information, doesn't reflect well on anybody and can both prolong and indeed intensify the conflict and possibly undermine public confidence. And what we would say is that you must not put information that you've learned in confidence about a patient in the public domain without explicit consent, even if the patient has disclosed some information of their own online. What you should usually do is limit any public response to an explanation of your legal and professional duties of confidentiality. It may be appropriate in some circumstances to give some general information about your normal practice, but I would suggest that before you do that, you do seek some advice. On the next slide, some points about what you can do if you are criticised online. Some of that reflects the options that we highlighted in the poll. And ignoring it is perhaps the hardest thing to do, at least initially. You may be familiar with the old maxim about today's news being tomorrow's fish and chip paper, and while that was true at the time, it doesn't work terribly well with online information. It's also true that you can't please all of the people all of the time, but I think most people who see a single negative review about a doctor or a practice will recognize that it is a single opinion. And I have to say, many of those negative comments are written in a way which tells you as much about the person who's making the post as it does about the person about whom they've posted. What I would say is that all of the approaches to dealing with these, which we'll sort of take in slightly more detail as we move on, carry with it their own risks, and you're always welcome to call the MDU to discuss the specifics of any case and what the options are. If we can move on to the next slide, what can be done on your behalf by your organisation if you're criticised online. It is probably easier and perhaps more prudent for an organisation such as a GP practice or a hospital trust for doctors working in secondary care to respond on behalf of the individual who's been complained about. And that, to some extent, is similar to the advice that Sarah gave about warning letters. Having the person who was complained about one step removed from it helps take some of the heat out of the situation and also allows the organisation to show that the person who has been complained about in a way which might be inappropriate is supported. And this sort of generic response that we're talking about here, as well as sort of taking some of the heat out of the acute situation, can also demonstrate that the patient experiences are taken seriously, and it may well help to settle the matter. But the person who does respond, whether it's the person directly affected or the organisation responding on their behalf, does need to remember that a breach of confidentiality will include confirming that a patient of the practice is a patient of the practice. You should also remember that you don't need to give the patient's name to breach their confidentiality. So if the patient's friends or relatives know who they are, a response which reveals any confidential information could be a cause for a formal complaint. It's also worth pointing out perhaps that the duty of confidentiality here is one way. You as a doctor owe your patient a duty of confidentiality because of your professional position, but patients don't owe you any duty of confidentiality. The confidential information in a medical consultation, such as what they come in with or the diagnosis or the treatment, is about the patient, and therefore it's the patient's information to do with as they please. And it's worth bearing that in mind, frustrating although it may be. Move on to the next slide. One of the things you can do when you're criticised online is that you can request that the website host removes the post. That really only works if the post breaks the rules of the site or is otherwise illegal. For instance, NHS Choices websites, along with a number of others, will set out the guidelines on what can and can't be posted, and it requests readers who consider a post to be offensive or unsuitable to alert a moderator who will investigate and may remove the posting. And similarly, Twitter and Facebook ban hate speech, threats, bullying and spam, but they'll only remove content that violates their terms. That may also be counterproductive because a patient who has a post removed may just choose to post elsewhere or consider going to the press, all of which can increase the potential interest in a post that might otherwise have been ignored by most people. Users on places like Twitter may also have many online friends or others who could become very vocal if they feel that other treaters are having problems, and encourage them to go onto the press with their story. There's also the right to be forgotten, which was something which came out of a European court judgment a number of years ago. And that essentially means that search engines can be approached to ask for information to be removed. And when that happens, they will certainly consider a request, but they will have to balance the right to privacy from the person making the request with the public interest in that information remaining available. And even if the information was removed from a search engine, it doesn't mean it's removed from the online world. It simply means that the ability to access via that particular search engine will no longer be there. And it also only applies to EU countries. Certainly, I would suggest if that's something which you're considering, is to take advice, for example, from your defence organisation before you take action to see what the best options are going forward. Moving on to the next slide, just as a summary of things that should be done, bear in mind the importance of respecting patient confidentiality at all times. Bear in mind that responding could make the situation worse. Possibly the most effective way of dealing with these things online is to remind the patient that there's a complaints procedure which they can use, and which is probably a more appropriate avenue for raising these types of concerns. If there are inappropriate comments, certainly I would suggest that you take a screenshot of those. That screenshot should be held, but not in the patient's clinical records. And that may be something which could prompt a warning letter or something like an acceptable behaviour agreement, depending on the comments. If there is press interest, or if there's likely to be press interest, we would certainly suggest that you offer no comment at that stage and contact us promptly. And the MDU press office is expert in dealing with this type of attention from patients or from the press acting on behalf of or generated by patients. On the next slide, just about some general social media advice. This isn't necessarily specific to being criticised online, but just things to bear in mind if you are a social media user. It's perhaps worth emphasising that it's safer to keep your professional and personal relationships separate. There's a clear difference between being friendly with patients and making patients your online friends. We would therefore certainly advise clinicians who use social network sites to keep your profile private and limit your access to friends only, and don't accept friend requests from patients. You should be professional about your comments, especially about patients or colleagues. Be cautious about posting anything which potentially may bring the patient or bring the profession into disrepute. And be aware that anything you upload to a social media site may be distributed further than you had intended. On the next slide, I would remind you that closed groups on social media aren't necessarily private or safe, and just remember how easy it is for someone else to take a screenshot of your comments, even on a private site, and to forward that on to others outside the closed forum. I mentioned the possibility of a pseudonym there, but that's really only appropriate for social life and the like. Anything that you do as a professional really shouldn't use a pseudonym, and that would be consistent with GMC guidance. You really are obliged to identify yourself. And just moving on to the final slide really is a note about defamation, which I touched on earlier. There's a definition to defamation, which is that it's a false statement made that lowers somebody's reputation in the view of a right-thinking person, and that its publication has caused or is likely to cause serious harm to the person's reputation. I'd make the point that defamation actions are lengthy, they're often expensive, and they can be very unpredictable. And they carry with them a degree of publicity. So the publicity associated with the actual action, bringing a defamation action, may be significantly more publicity than the original offending post. It's also worth bearing in mind that the legislation, the Defamation Act of 2013, provides a number of defences to a claim of defamation, which include that the matter was substantially true, that it was an honestly held opinion, that it was in the public interest to make the statement, or that it's in a scientific or academic journal or protected by privilege. And NHS Choices makes the point that just because you disagree with an opinion or believe that it's wrong, it doesn't mean that it's defamatory if it's published. So hopefully that was a helpful run through of questions arising from criticism on social media. There's a certain overlap with what Sarah talked about in terms of dealing with that, with how you deal with warnings and the like. If I can bring Sarah and Ed back in at this point to deal with some of your questions. And Ed, just if I can say that I think Ed, you're muted there.
Sorry, can you hear me now? It was taking a little while to unmute. Perfect. So thank you, Sarah and Ed, for those presentations. And I'm really grateful to the audience for some really interesting questions. If you've noticed, I'd cut some of your questions out or deleted them. It's just because we've had varieties of those before. And I'm going to try and deal with these with some kind of theme. So apologies if I don't get to you all. But there's some really interesting things that I think we should build on here. The first question is I guess a fairly fundamental one, which is, you know, if you've gone through this process of issuing a warning letter or a behavioural agreement, things haven't worked out, what are the criteria that have to be met before you decide to remove a patient from your list? Sarah, sorry, I think you're muted.
I was on mute there. So absolutely, I think you have to remember your contractual obligations. So your role as a holder of a patient list, and the LMC can advise you on that. But in general, there is an expectation that unless there has been violence or threats of violence such that you've called the police, there is an expectation that that warning letter will have been given. And that's why it's important to deal with these things in a timely way, because then if the patient has had a warning letter and nothing has changed, then you're following the rules, as it were, for ending your relationship with a patient on a professional level. I think it's important to make sure that that is there as well.
Great, thank you. That's really, really helpful. Ed, do you have any other comments on that?
Only to say, my experience is that the GPs are remarkably tolerant of patients who behave in a way which is not acceptable. And I think often, you know, they will allow for patients whose behaviour is, you know, to some extent a manifestation of an illness or frustration about systems which are outside of their control. But if you recognise that a patient's behaviour has crossed the line, it's certainly important to consider that possibility of a warning, because what you don't want is for the same patient to behave the same way 5, 6, 8, 10 times, and then to sort of the 11th time is the straw that breaks the camel's back, but you haven't got to the point of previously issuing a warning letter. If you then remove them from your list without having issued that warning letter, you could be vulnerable to criticism, irrespective of how tolerant you've previously been. So that discussion about warning letters and issuing them when you think it's appropriate does give you very good grounds to take the next steps when it becomes necessary. And in many cases, it means having issued the warning letter, that next case never happens because the patient does sort of realise that they've maybe gone too far in the past.
I think it's important to be consistent as well. And if you say that this is likely to happen if your behaviour carries on, then you need to follow that process through so that you sort of consider if matters are escalating and so on there then. And often sort of making decisions, I guess, as a practice, as a partnership is really important, because sometimes patients may try and perhaps play one doctor off against another and so on. So actually sending out a warning letter in the name of the practice when the partners have discussed it and so on, I think sometimes adds more credence to that as well, that we're all saying that this behaviour is unacceptable, and you know, we want you to change and to work with us.
Great, thank you very much, Sarah and Ed. Actually, your answers have kind of led quite naturally to a couple of things. The first thing was a comment that somebody made about, well, look, you know, does somebody need to sign it? Can it be signed off by the practice or the partnership? And I don't think there's necessarily a right or wrong answer to that. There's nothing wrong with somebody taking responsibility, but being clear that this is a partnership decision or a practice decision. Equally, you can sign it off as a partnership. The other question we have that relates to the point you made was whether there's a minimum waiting period after the warning letter before you act. But I think, judging by what you were saying, Sarah, and this is my view as well, is that if you've given that warning, it's clear and appropriate and the behaviour recurs, you really should act upon it, or at least bring it up with the patient again, because otherwise you find that a year's passed, that old warning may have expired and you can't act.
Absolutely. So there isn't a sort of minimum time period. And I think just dealing with these things as quickly as you can. Of course, you have to have the discussions. You might need to collect evidence, for example, statements from your staff about what somebody has said or the behaviour that they've shown. So you have to have enough time to do that, but you need to get that warning letter out as soon as you can after the unacceptable behaviour, and then to follow through with that if there are any further matters of concern.
If I could just maybe add to that, sorry, is to say I think it's often a good idea maybe to send that warning letter as soon as possible, but send it by recorded delivery and retain records of both that it's been posted and also to retain the track and trace evidence that it's been received.
Absolutely.
Thanks, Ed. Just turning to what you said as well about how remarkably tolerant GPs are, and as a hospital doctor as well, we regularly see things where there's behaviour tolerated within a healthcare setting that certainly wouldn't be tolerated outside a healthcare setting. One of our sort of participants asked, well, look, how do you deal with a situation where the patient asserts that all their behaviour relates to their mental health? How do you deal with that situation?
Well, I think the GPs or the hospital doctors are in a very good position there, because they are clinically experienced and can identify very clearly, for the most part, when somebody's mental health or the impact of their physical health on their mental health is a genuine problem, and when it's simply a reflection of bad behaviour rather than a mental health problem. I think clinicians are probably best placed to make that decision themselves. They might want to allow a certain degree of leeway or give somebody the benefit of the doubt perhaps once or twice, but if it's repeated behaviour and if there's no other evidence that there's a mental health problem there, then I think you can take that and weigh it accordingly.
I think sometimes as well we do see sort of really good warning letters that have been sent in for our review, and they will perhaps say, we recognise that caring for your relative with a life-limiting illness is really stressful. Here are the carers support groups and so on, but we still feel that our staff should be able to work in an environment which is free from verbal abuse and so on. So I think that there are ways of signposting people to support and recognising that they're under stressful circumstances sometimes and supporting them with that, but still saying that they have that you have obligations to your staff and to yourself that you don't take that verbal abuse.
Great, Sarah, thank you very much. Now I'm going to move on to the next fairly big theme, which I'll draw a few things together. The first is that a couple of the participants in the webinar have said that we sometimes send out warning letters and the patient always disputes it. What do we do about that? And just thinking about your talk, Sarah, I think that's why you were so clear about the warning letter should clearly describe the behaviour, and that obviously appropriate records or incident forms should be filled in when that happens. So you've got a record of what went on.
Yes, absolutely. I suppose it's possible on rare occasions you actually need to gather some more information before you can make a final decision. And in those circumstances, you could ask the patient to provide their version of events as well. But I think generally, before issuing that warning letter, you would want to have, I suppose, the sort of evidence of what's gone on, whether that's a review of CCTV or listening to a recording of a phone call, or reviewing the relevant clinical records to help you to make that decision. I think very rarely, if you felt that there wasn't enough information to be able to issue a warning letter, it's probably helpful to ring our advice line and to talk things through about the options in those circumstances then.
Thank you. We've also had a couple of questions about when it's appropriate to record these sorts of incidents in the patient records and when the records should be kept separately. Have either of you got any observations on that?
Yeah, I think that there's a couple of things specific to that. I think if you look at my understanding of the contract regulations, the GMS contract regulations, which most GPs will be following in these situations, I think there is a specific requirement in the case of patients who have been removed from practice lists on account of violent behaviour, in those situations where the police have been called, that specifically should be recorded as part of the contractual regulations within the clinical records. And I think that's probably to protect the next set of GPs who have to look after that patient, so they know that there's something about that. Aside from that, I don't think there is a particular contractual obligation to record this information in the clinical records. And my suggestion would be that if there's information which is clinically relevant to the warning letters or to the removal, other than that specific situation, then that should be recorded in the clinical records, and the clinical information should be limited to that. Other than that, I think the warning letters or the reasons for removal need to be recorded. That needs to be carefully documented for future reference, but probably separate from the clinical record, such as, for example, in a complaints file.
Great, thank you very much for that, Ed. Sorry, I was scrabbling about trying to get through as many of these as possible. There was a question asking about whether a behavioural agreement has to come before a warning or vice versa. I mean, to my mind, it would really be horses for courses, wouldn't it? There'd be some circumstances where there's abusive behaviour or rude behaviour where you're dealing with that through way of a warning. There are some other circumstances that people brought up where there are unreasonable demands on the practice, or communicating through channels where you've been very explicit that these are not monitored, but sending clinical information through those and expecting a response in a short time scale, where a behavioural agreement would seem a more sensible way to approach it. What do you guys think?
Absolutely, I think you have to these are all tools that are in your that are in your gift to use, and I think it is trying to think, well, what's going to be the most effective way of getting this behaviour to stop. And so certainly you may feel that encouraging better behaviour through a behavioural agreement in some cases would be better, and if that behaviour agreement doesn't work, to then issue a warning. I think it's perhaps harder to argue the other way around, that once you've issued a warning, you're then going to have an acceptable behaviour agreement. But there may be times where actually you want the two almost in tandem, that you're setting out the expectations on the patient, and that you're making very clear in your letter that if your expectations are not being fulfilled, the possible consequences for the patient, they're being very clear about that.
Great. Now, we've got a lot of questions on the social media side that I will definitely come to. There's a couple of other things I just wanted to flag up in relation to these sorts of things. Now, firstly, we've had an observation as look, is this all relevant in a hospital setting, as this is mainly about GPs? Well, actually, yes, most of this is targeted at GPs, because obviously GP surgeries have their own responsibilities without management departments to actually deal with this quite often. The thing that I would say that is absolutely universal is that you've got systems for reporting adverse behaviour that should be done, and the steps in terms of how you deal with this behaviour is making clear to the patient what they've done that's not appropriate, and doing so in fairly precise terms, setting out what can be done to remedy the behaviour, and the consequences of when that might happen. And the other thing that has been said is that we've had a couple of questions about whether if you're handing over care to another party, is it appropriate that a handover takes place in these situations? And normally, I think it probably would be. Would you agree with that? The doctor should at least facilitate the transfer of care, even if that relationship has broken down.
Absolutely. I mean, I think through all of this, we recognise that you're having to deal with the stress caused by the patient's behaviour, but that you do have obligations to provide that clinical care as appropriate, and to make sure that the handover is there, or that if the patient is removed from the list, that they know how to access care and to register with a new GP. So I think that's really important, because you have to still, I suppose, follow the rules as a professional. And making sure that you've handed over care and that the patient knows how to access care when they've been removed from the list. That's really important.
And another couple of really quick things, turning on to where we record information. We've had a couple of comments about what happens if the abuse takes place during a consultation. If it's verbal abuse or racist abuse, can that be recorded in the patient record?
Yes, I mean, my view is that anything that's clinically relevant should be documented there, and generally, if that forms part of the clinical consultation, it would be reasonable to document it there. I think if you were dealing with circumstances where you felt it wasn't appropriate to document it, you would need to consider where else you could document it, and really is, I think it would be difficult to see that it would be appropriate to put notes of a clinical consultation anywhere other than the clinical records. I think it's more difficult perhaps where there's been bad behaviour in the waiting room and so on, and it's been witnessed out with a clinical consultation, and then you would have to make a judgment call as to where that is best documented, really.
Great, thank you very much, Sarah. Now, I promised that we'd move on to some social media questions. There's a really intriguing one that I found that came in early, which was when the patient participant group was asking for the practice to kind of respond to patients complaining via the village Facebook group. What do you think about that, Ed?
Yeah, I think if you become aware of complaints which are being made on the village Facebook group, then it's certainly appropriate to deal with them. But I don't necessarily think that responding to them by the same means that they were made is the best way forward, because you're inevitably going to get into issues of patient confidentiality if you're trying to respond to a generic Facebook group. It's bad enough responding to the patient directly on Facebook and what might be an open forum, but to respond to a generic sort of community group is not going to be a successful way of dealing with complaints, and it's going to certainly lead to areas of potential breach of confidentiality. I think what you can do is if you become aware of something on a Facebook group like that, is to highlight your complaints process. Certainly say that you'll take any complaints that come to your attention seriously and investigate them in the usual way. And if you know who the complainant is, then you can certainly contact them directly through the more traditional means.
And touching on that, we've had a couple of people raising the kind of thing that we do see where, you know, a patient may have complained and then an anonymous post turns up on the web, or you have something coming into the generic practice email from a kind of, you know, an account just set up for the purpose with abusive comments, etc. And we're being asked kind of what you would do about that. My thoughts on this, because I had a case like this recently, and the doctor's concern, which I had to say, look, I think was a fundamental barrier, is that they couldn't be sure who wrote it. So making an accusation in that setting is not appropriate. But on the other hand, if you receive threats of violence or really abusive comments, even if they're anonymous, it's perfectly reasonable to report those to the police in that setting. How much headway they can make is another matter, but it's perfectly reasonable to do that, because that's another option that was raised. Have you got any other thoughts on that?
Yeah, I think patient confidentiality is important, but it's not a shield behind which, you know, criminal activity can be hidden, and it's not a way that patients can be exempt from being accountable for, you know, entirely unacceptable and potentially criminal behaviour. And, you know, an anonymous post or an anonymous email to the surgery may not be from a patient, and on that basis doesn't carry with it the obligation of confidentiality. You know, it's perfectly reasonable to report that one to the police, and the police can carry out their own investigations, including, if necessary, looking back and identifying things like IP addresses that, you know, where the source material was.
And another couple of things have come up. I appreciate we only have 5 minutes left. We've got a comment here saying that we record all acceptable behavioural agreements in the record, as this acts as a warning to staff where it may be necessary for them to have a chaperone or pre-warning of an abusive patient. Surely this is necessary. I don't think there's a particular problem with there being a flag in the notes that other information about this patient may exist, or that there is an agreement in place that needs to be looked at to manage consultations. You know, so I don't think we're saying that that's not appropriate. We have another issue here saying if a patient becomes abusive at reception, is it acceptable to video record the incident by a member of staff to use as evidence?
Okay, I guess with this sort of thing, you always need to be very careful as I suppose, a data controller sort of within the practice. What are patients told about how their data might be collated and how it might be used? So I think many places now we see, you know, in car parks and so on, that CCTV images are being recorded for the purposes of. I think it is easy to sort of have that generic notice there. It may be more difficult to justify filming a patient then, especially if other patients are nearby, and this is something that we sometimes see when we're asked about patients recording in the waiting room, about not breaching the confidentiality of other people and not using data in a way that it wouldn't be, that I suppose the data subject wouldn't expect it to be used. So I think you'd need to take a little bit of care in considering doing that. Having said that, if there's a criminal act or something like that that is going on, then you may feel that it's perfectly reasonable to video or to take you know, to take evidence of that act there.
And I think this is the frustration with data protection legislation, isn't it? It's asymmetric. So if you're a business or a doctor's surgery, the obligations apply to you. If you're an individual, then you can generally record interactions with other people for your own use. And that is frustrating. So if you're recording calls, if you're using video recording, there is guidance on the Information Commissioner's website. Make sure you follow it, because that can be useful evidence, but it needs to be done in a structured rather than an ad hoc way. We've had another couple of really quick things. It said, can you write a letter in response to a social media comment and say, look, if you know who the patient is, it seems to be inviting a response. You can certainly invite the patient to take the discussion offline or try and respond to the issues they've raised. Again, just be careful and know that you're dealing with the right person. Sarah, this may be one for you. Can a GP ask a patient to sign a good behaviour contract before joining the practice? Now, the question's asked here to say, ask all patients to sign a good behaviour contract. I don't think you can do that as a blanket requirement, but there may be some instances, do you think, where a behavioural agreement might be appropriate at the start?
Yes, I suppose that perhaps if you're looking at a patient whose behaviour has caused concern in the past, they perhaps moved away and then they've come back and so on, that it would be reasonable to have a conversation or an agreement at the beginning of that. And also, I suppose that when patients are given a patient information booklet when they register, to point out the zero tolerance policy of your practice and that sort of thing as well. So I think having a blanket acceptable behaviour agreement probably may even dilute the effect of the times where it's actually genuinely needed. But I think absolutely reminding patients of you need to have a two-way relationship that's based on respect, and that's what you expect from them, and that's what you are going to deliver as well. So I think there's certainly no harm making reference to zero tolerance policies and so on when patients register and on your practice website and so on.
And so a couple of things to round up. I'm conscious we've only got a minute left. We've had a lot of questions about whether we have template letters for warning letters, etc. What I would say is, if you're sending a warning letter, it's a complicated situation, send it in to us, we will review it. We're more than happy to do that. We've thought about template letters. My personal view on these is that I think they're potentially problematic. The real thing about warnings is that they're personalized, they're targeted to the behavior. It gives the patients an opportunity to understand what they have done which is inappropriate. It's explained precisely. They are given then the opportunity to challenge it if they think that description is inaccurate, and it explains clearly what the consequences are. And really, if you can avoid a template, make it specific to the circumstances, that's really helpful. And as a very final thing, we're asked what's the underlying issue when patients make complaints, what are the practical things we can do to avoid problems? Well, I think, you know, if you've worked in the NHS over the last sort of 18 months, you're all experts at managing those expectations, communicating, trying to diffuse and de-escalate these situations. And these situations, though they're incredibly time consuming, are really rare given the number of consultations that are up there. So I think you already know most of those things. We had another observer saying that communication was the key. That's absolutely right, and trying to de-escalate situations. But to be honest, most of the complaints really relate to the context in which you work. If you're a GP, it may be about, you know, prescriptions, appointments, delayed diagnoses. If you work in hospital, it may be about treatment, and they're really context related most of the time. And frankly, the complaints are still remarkably rare despite the challenges over the last year and a half. So I really want to finish on that positive note and to thank Ed and Sarah for some really great presentations, and thank you for your engagement and some really interesting and well-considered questions. So thank you very much for joining us.
Thank you and good night.
Thank you. Goodbye.